Hey everybody, it's Kmet, condominiums.com. Thanks for joining me today. Today we're talking about all things SB4D, the basics. So I just wanted to go over the basics with you, just in case you haven't been exposed to this information fully. We'll go ahead and take the time now to go down the list of to-dos. You know, what if, depending on your location, depending on the type of community you have, what do you have to do to comply? So, we're not going to discuss the right or wrong, whether this needs to be amended or changed or whatever. We're just going to go down what is and just tell you about that. So, real basic video here, but if you haven't heard this before, you need to hear it. Okay, so first off, the law requires condominium and cooperative association buildings that are 3 or more stories in height to have a, quote, milestone inspection of those buildings. Structural integrity by an architect or engineer when a building reaches 30 years of age and every 10 years after that, or 25 years of age and every 10 years thereafter if the building is located within 3 miles of a coastline. Okay, you got that? So all buildings have to be inspected, have a milestone inspection when they're 30 years old, and 3 stories or more in height. And then all the buildings within that 3-mile radius, they're saying you got to do it by the time they're 25 years old. Okay. The law also requires, if a milestone inspection is required and the building certificate of occupancy was issued on or before July 1st, 1992, the building's initial milestone inspection to be performed before December 31st, 2024. So that'd be a year, 2 years from now, roughly. I'm making this video January 17th. So, okay. It also requires that a phase 1 milestone inspection must be commenced within 180 days after an association receives a written notice from the local enforcement agency. That's going to be your local building official. So that's the deal. It also requires a phase 2 milestone inspection if there is evidence of, quote, substantial structural deterioration as determined by a phase 1 inspection. Now, I'm going to do a couple of videos on what's required and how it goes, and possibly some estimated costs on the phase 1 inspection and the phase 2 inspection, because they're different. I've done them both. So I can walk you through just what each one of those is going to entail, the logistics of it. You're going to have to give access. You know, you got to set this thing up. You know, can I get into this room? Can I get into that room? It's going to take some logistics to get it done for sure. But anyway, so let's continue down the list. It specifies the minimum contents of a milestone inspection report. So I have documents all over. I have here, this is something for later, but this is the Florida Building Commission recommendations on milestone structural inspection requirements. Okay, it's about 30 pages, and this is a draft version, but it's pretty good, I must say. I mean, they've done some diligence on it. So again, I'll probably just do a separate video on that later. All right, it requires inspection reports results to be provided to local building officials and the associations, and requires an inspector prepared summary to be provided to unit owners by mail and by email to unit owners who have consented to receive notices by email. Let me just say, if you haven't given your management company or your board or both your email, do it, and suggest that all communications be done that way, because this is silly. The people that don't get involved in their community enough, let's say you're an investor or something, and you just don't want to be bothered with the emails, it's too bad. You are a part of that community, and being a part of that community requires your involvement. Your involvement requires emails, because what if there is an emergency, okay, and your phone, you're out of phone, whatever, at least the communications can be broadcast, sent out. As a manager, it's really more convenient. It doesn't just save me time. I can document things easier. I can make sure, hey, yes, everybody's at least been sent an email, and I can include PDFs and all the backup information I need to in those emails. So to keep you fully informed so you can make better decisions, phone calls are just not enough. And if you create a bulky communication situation, that only hurts you, and it hurts the community. So be a good community member. Show some community love. Share your email. Request that your communications be done by email. And please, let's step into the email age and get that done. All right, now the keywords in this particular step were inspector prepared summary. So, I've read a lot of engineering reports, and I've read a lot of project manuals. Project manual is a very thick booklet. I'll show you guys one. I have a bunch of them. In another video, we'll go over what those look like. And but I mean, you really need to be an engineer or somebody who's been living that life for a while to be able to understand all the terms and conditions of that. They use terminology, language, different things. It's not intended for a layperson to read. It's really intended for the contractors bidding the project and the suppliers to read. Mostly the contractors bidding the projects. So the reason here is for this language is so that whoever drew up the law knew that there'd have to be a summary that would be more in layman's terms, that the association people, the management company, the board members, the homeowners, and anyone else involved that needs a copy of that would be able to read that and make sense out of the summary. So I think that's actually an excellent part of the law. The law also requires that the contract between an association that is subject to the milestone inspection requirement and a community association manager, or CAM, or CAM firm must require compliance with those requirements as directed by the board. This is another key thing. The fact that they brought management companies into this and managers, and my position on that is, like I've said before, I can never tell a board member what to do. They're telling me what to do. So to make management companies or managers subject to fines or penalties because we don't act, because the association didn't act. Now I know what this is saying and I know what the intent, but I think this needs to be clarified. Because to be fair, a manager can lose his job, he can get fired, and there's a good chance of that happening if the manager says, "Hey, Mr. Board Member, you've got to comply. You've got to do." The manager's saying, "This is the law. You've got to do this." And if a board member says, or a complete board says, "We're just not doing that," well, what do you do? I mean, it's really a rock and a hard place for the manager. So the legislature wrote this in, but I really think this needs to get amended so that it's very clear that the manager's not going to get in trouble for not doing that if the board doesn't do that. It's really the board's sole responsibility. Whoever they hire, whatever method they choose to do that, what if they don't involve the manager? Okay, I mean, that could actually happen. They can say, "You just stay out of this, we got this," whatever. What's a manager going to do? I mean, it really puts a management company or manager in an odd spot for the legislature to assume that they have more power or more rights over a client than they do. That's all I'm saying. Okay, so also, next item. It requires a local law enforcement agency to review and determine if a building is safe for human occupancy if an association fails to submit proof that repairs for substantial deterioration have been scheduled or begun within at least 365 days after the local enforcement agency receives a Phase 2 inspection report. I think that pretty much speaks for itself. One of the things that can happen is they can shut you down. If they deem a building to be unsafe and you haven't acted in accordance with the law to comply with that law with regard to safety, they can evacuate the building. They can do that. And it can happen. I've seen it happen under different circumstances, but that can happen. And there's other reasons that can happen too. If your fire alarm doesn't work right and you're not notifying the fire alarm monitoring company, if that system isn't working, the fire marshal can come out and say, "Sorry, folks, you've got to have monitoring." I mean, that's called a fire watch. I've had to do those before. That's not fun, especially on a weekend. You have to physically watch the building and walk the halls and do all that and sign in and log it. A person has to be the monitor, while that system is down. So anyway, there's a precedent for this, is what I'm saying. So all right, requires the Florida Building Commission to make recommendations to the governor and legislature regarding the inspection requirements in the bill and inspection for other types of buildings and structures that are 3 stories or more. That's this thing. Okay, that's the Florida Building Commission recommendations on milestone structural inspection requirements. They've done their job. So that's that. The law also gives unit owners the right to inspect and copy as official records the milestone inspection report and all other inspection reports relating to structural or life safety, and gives renters the right to inspect the milestone inspection reports. Of course, I'm glad to put this in there because if you're a renter, you're a resident. I mean, I know you don't have the same rights as an owner, but gosh, if you're in a building and it's unsafe, you sure as heck want to know about it. You'd want to, if you have the ability to interpret an engineering report, or at least the prepared summary, then you can make the decision for yourself whether you feel safe in the building or not. And then that would be between you and your landlord, whether to stay there or not. But, and that's a whole nother industry being affected by this, the real estate rental industry. Okay, and then just the whole official records part of it. So these records, this is going to be sunshine law. This is going to be transparent. Everything to do with this process is going to be sunshine. So don't get any ideas about not, if the report comes back bad, just face up to it. Just be truthful. Just say, there it is. And if you're on the board or you're the manager, there's no place to hide. You've got to share it, you've got to publish it, you've got to address it, you've got to do something about it, and you got to be responsible. And it's a fiduciary level now to a board member. It is so stated in the law that now publishing these reports and acting on it in compliance with the terms and conditions of the local enforcement agency is now a fiduciary level offense or liability if you stumble into that. So don't do it. Just do what you got to do here. It requires the developer's turnover inspection report to comply with the milestone inspection requirements. Okay, requires which means they can't waive reserves. If your reserves, I believe this is correct. If your reserves are in your original budget, because developers like to lower the fees for sales purposes, make it look like it's really cheap to live there. But in fact, they're just deferring reserves and not funding them, because reserves can be a big part of the budget. They're going to be a huge part of future budgets of condos and HOAs. You'll see once these inspection reports come back, and these reserve analysis, also required as a part of this is the reserve analysis situation. That's going to make everybody come clean with reserve funding also. That's going to it's going to require a true cost of future replacements. All right, requires associations to report to the Florida Division of Condominiums, Timeshare, and Mobile Homes the number of buildings that are 3 stories or higher in height and the total number of units in such buildings on or before January 1, 2023, and requires the division to publish that information on its website. Okay, so if you have any buildings on your property or in your community that are 3 stories or higher, you have to report that. You should have already reported it. I believe, and I can confirm this, that if you don't have any buildings 3 stories or higher, you don't have to report at all. I'm gonna check on that, but I'm pretty sure I'm right on that. Okay, requires developer and non-developer unit owners to give prospective buyers of a unit a copy of the inspection prepared summary of the milestone inspection report. That's full disclosure. Realtors, beware. This whole, the old trick, well, are you gonna have an assessment? You're gonna be doing some work. If it's not in the minutes, then it's not public information. It's not anything we have to disclose. It's not something a realtor would have to tell a buyer. Those days are gone. Realtors, I hope you're aware of that. You better ask, and if it was me and I was selling a unit, I would have the owner disclose, and if not, sign a form saying there's no such report on file or something like that. I'm sure you all will figure that out. It requires developer and non-developer unit owners to give prospective buyers, just read that. Extends the jurisdiction of the division to investigate complaints to include complaints related to the procedural completion of milestone inspections. All right, so now the division can come and get in your business if you don't comply. So they're saying you got to do this, and don't make us come and tell you to do it, because this is going to make it a whole lot worse. All right, here's more. Oh my goodness. 15 minutes already on this thing. I'm telling you, it's crazy. I'm going to try and jam it all in one. This is about reserves. Regarding the funding of reserves for the continued maintenance and repair of condominium and cooperative buildings, the law, requires condominium associations and cooperative associations to complete a structural integrity reserve study every 10 years for each building in an association that is 3 stories or greater in height. Excuse me. Just gonna take that. Sorry about the swishing there. All right, that's what it is. Structural integrity reserve study. Not just a reserve study, not just paint, roof, and paving. This is structural. I already have the information on what they're recommending and what they're defining as visual inspections, structural inspections, and structural reserve studies. So we'll do another video on that, but just to continue the list, so this video doesn't get too long, just so you're taking notes and doing your thing. Requires associations existing on or before July 1st, 2022 that are controlled by non-developer unit owners to have a structural integrity reserve study completed by December 31st, 2024. So here's the deal. You have some time to get this structural reserve study done, okay? And that's your time, December 31st, 2024. Don't wait. The industry only has so many reserve study companies, and it takes time to get a reserve study done. And this isn't just your call it in reserve study, because I've done those. I mean, some of these reserve companies, don't get me started on it, but they never come to the building. They never even look at it. They just, whatever they can find online, whatever they can determine from satellite, that's what they do. And they base their entire reserve study on that. And you know why the industry has let them get by with that? Because it's cheaper. It's a lot cheaper. They have a much higher profit margin when they can do that, because they don't have any travel, they don't have any physical bodies that have to be on site. The logistics of that is cumbersome. It's not efficient. Letting people in and out of rooms, looking at everything. What if they discover something that is built after the fact or after the CO? And then, okay, well, we need to account for this. Seawalls. How many people reserve for seawalls? Seawalls are structural. I don't know where seawall, like I said, I live this stuff. And I know that if I made the list, I would say, well, what about seawalls? So we'll see where seawalls fall into it. But seawalls are structural. Side note. I've managed buildings before where there's all of 8 feet between the actual building structure of a high rise, let's say 5 stories this one was, and the seawall, and then the bay, which is really kind of the extended Gulf. And it was on a corner. So there's a lot of wave action, a lot of stuff. In fact, we had to add rebutment and rubble and different things to the seawall, and a lot of maintenance had to happen to that seawall. That association didn't have a reserve for that seawall. It simply assessed owners when they had to do the additions to it that they needed to. And there's just no way that they would have on their own just done that. It may be that after these structural reserve studies, if a seawall is determined to be structural, in my case it would be, because here's what happens. You lose that seawall, you lose the dirt that is holding up the foundation of that building, whether it's on pilings or not. You're going to lose substantial structure, okay? So someone's going to have to define that. But in that case, absolutely, you have severe property damage. In fact, I'm sure, like I said, the insurance companies are going to have an eventual voice in this thing. They're going to say, well, we probably need to see your budget to verify that you're funding your reserves, because they want to know that their property that they're insuring is fully protected. They want to know you're going to pay, not them, or if they got to pay, you're paying too, with deductibles, and it's an odd marriage, that whole setup. All right, let's move on. Define structural integrity reserve study as a study of the reserve funds required for future major repairs and replacement of the common elements based on a visual inspection of the common elements. Okay. Requires the study to include a visual inspection, state the estimated remaining useful life and the estimated replacement costs of the roof, load-bearing walls, or other primary structural members, floor, foundation, fireproofing, fire protection systems, plumbing, and any item with a deferred maintenance or replacement cost that exceeds $10,000. So they're not messing around. Requires a visual inspection to be performed by a person licensed as an engineer or an architect. Okay. However, any qualified person or entity may perform the other components of a structural integrity reserve study. What does that mean? We're going to do some research on that. But if I read that again, requires a visual inspection. This is the structural integrity reserve study. This isn't the actual building inspection, the milestone inspection. This is just the reserve study. It says it requires a visual inspection to be performed by a person licensed as an engineer or architect. Your costs just went way up on that. However, any qualified person or entity may perform the other components of a structure. So that means they're saying the people that used to do it before, which were definitely not engineers or architects, they used to supply you these reserve studies for your budgets. No more. I mean, they can do some of that, but the engineer has to do the structural part. All right, that's a very costly update. All right, 2 more items. Requires a developer to have a structural integrity reserve study completed for each building in the association that is 3 stories or more in height before turning over control of an association to the non-developer unit owners. Finally, provides that it is a breach of a board member or officer's fiduciary duty if an association fails to complete a structural integrity reserve study. A breach of fiduciary duty. So, I'm not going to talk too much about fiduciary and what it means, but I think you all know what it means. If you own property and you're a property owner, you're watching this, or a manager or whatever, you know that that's the next level up. Okay, now we're taking everything off the table. You got to do this. And if you don't do it, there's going to be penalties involved. Okay, it's going to hurt. So don't make that happen. And you could be liable, maybe. You could be certainly accosted, okay, by other people saying, you're whatever. So, or it could actually be a state function, because as we were reading earlier, extends the jurisdiction of the division to investigate complaints to include, but maybe not limited to, complaints related to the procedural completion of milestone inspections. Do you think that they're not going to look at conducting these structural integrity reserve studies in the same way? I bet they are, but we might have to wait and see whether that's true. So, all right, this is our SB4D, Building Safety Law, Class 101, the basics, with a little bit of commentary to help expound and maybe help you understand where you're at with this. So each one of you watching this video is going to know how that applies to you. You know your community, you know your buildings, you know your multi-condo or not, the whole bit. And hopefully I've explained it in a way that can either just ease your mind to at least know what you got to do, when you got to do it, and or not. So that's the deal. All right, well, listen, come on down to condovoice.com. If we can help you in any way, send us an email through our contact system at the website. We'd be glad to help you if we can. Thanks for watching. You all have a great day.